Good afternoon. Thanks for joining me today. And we are talking about how to defeat medical provider claims in New Jersey. If you're like me, these are the bane of your existence. I'm so frustrated by these and I feel bad for my clients. I mean, I always feel bad for anyone who's drawn into the spider's web, the cabal of evil, predacious attorneys, corrupt, crooked doctors, judges who just don't care, a hostile, indifferent court system. I mean, maybe I'm just ranting here today, but one of the things that makes me feel the worst is when my clients get dragged into medical provider claims in New Jersey. It has turned into a cottage industry of predatory practices, everything from robo-filing by certain plaintiffs' law firms, to judges who are just indifferent to the plight of the employers, and to just a ridiculous statutory scheme just dragging us into these issues. So I'm going to talk today about how to defeat, destroy, overcome, beat these medical provider cases. And I'm going to give you some real world examples. And one of them I put into today's meeting materials. Your handout materials that you should have in front of you include a decision we recently got that's going to be helpful to you in your cases. So welcome aboard to a topic that's near and dear to me. I just had a client call. Stephanie called me up and she said, Greg, what should I do with these medical provider cases? I was like, come to my webinar today at 1 o'clock. And she said she was going to send her people here. So if Stephanie sent you over here today, sorry guys, it's because this literally just came up today in one of the cases we just gave her some advice on. So welcome aboard, Stephanie's coworkers. All right, how to defeat medical provider cases in New Jersey, and I want to defeat these things. Just a reminder, this presentation is for instructional purposes only. I'm not your attorney in this or any other matter. Of course, I'm an attorney. I have to have disclaimers. What's my job? What do I do for you? My job is to get and stay in control of your New Jersey workers' comp case. We want to move these cases to conclusion. That's my job. Okay, I never lose track of that. Please ask me questions today in this presentation. Please go ahead. Yes, this is going to be recorded for posterity. There are videos of all of our presentations going back for 9 years on our website, so you can watch any of the presentations on any of our topics. We also publish these all as podcasts. But when you ask me a question, I want to encourage you to ask questions. First of all, it makes this so much more fun and interactive for me. Otherwise, it's just me talking at you, and I hate that. But it's also useful for your co-viewers or co-attendees. Maybe they had that question in the back of their mind and they didn't want to answer or ask it. So please do. It also makes it more useful for the people that are going to watch this back on video or audio playback because they don't get a chance to ask questions. So please ask it. If I'm coming up with a point, it's confusing, please ask me to clarify it. Now, I promise I will not embarrass you if you ask a question. I will say your first name so you know I'm answering your question. I will then read the question out loud so that our viewers at home know that I'm answering your question, and then I will give you my best answer. And again, this will be recorded so you can come back to this if you need to in the future. All right, our presentation, what are we talking about today? What are these medical provider claims? What are you talking about, Greg? Why are you ranting? What kind of discovery should we expect? How do we handle these? What are we going to do? What are the milestones? How do we get rid of them? How do I defend the cross-jurisdictional ones? And I think that's what's driving a lot of activity right now. And then what is the future of them and how we're going to resolve them? So what is a medical provider claim? Why did Greg think this was a great topic for today's webinar? Why does he keep coming back to it? Well, I'll tell you, we're defending thousands of cases. We have something like 4,000 cases in active litigation today. And a huge proportion of them, particularly in my New Jersey practice, is medical provider cases, right? How do we defend them? How do we dispute them? I want to educate everyone. I wish the judges would listen to this presentation so they could understand the frustration and frankly, the disappointment we have as employers and carriers in this state dealing with this ridiculous problem. These could be resolved quickly and amicably, but again, we need help and we need to get aligned on that. So what are we talking about? A medical provider claim is specifically allowed under the New Jersey statute. And the statute was amended in 2012 to allow them. Officially, these claims are called medical provider application for payment or reimbursement of a medical payment. And essentially, the medical provider is saying, hey, I provided treatment to your workers' compensation injured worker, and I want you to pay me for that treatment. But most of the time, this applicant, because there is no petitioner in this case, no plaintiff, the applicant is the medical provider. It's a doctor's office, a surgery center, an anesthesiologist, or just think about all the quacks and crooked physicians out there. That's who's bringing these, okay? We're talking about same-day surgery centers that are fly-by-night, shady operations. We're talking about all the shady, unnecessary stuff like neurophysiologic testing services where the tester is not even in the building, they're on a telephone somewhere. I mean, all the shady stuff, all the crooked quacks, that's who's bringing these cases by and large, okay? Sue me if you don't like me saying that, but they're mainly quacks, they're crooked doctors, and they are surgery centers, okay? That's who brings these cases. And they're essentially saying, I provided treatment to your injured worker, and now you owe me money. And oftentimes they're not saying you owe me money, they're saying you owe me more money, okay? Because the most of these disputes are about how much the provider was paid. Now, the statute of limitations has been found by case law to be 6 years. And it's 6 years that runs from the date medical care was provided. So you're right, we're starting to see we're seeing provider claims for treatment that was rendered in 2018, 2019. That's a long time ago. The applicant has the burden to establish that the treatment was related to a workers' compensation injury, and the applicant has the burden to establish that New Jersey's workers' compensation court would have had jurisdiction over the underlying workers' comp claim. Of course, the injured worker doesn't have to file their own claim, but they have to show that they could have. Now, I know this is going to sound crazy, but for the first decade of me defending these cases was me arguing that this court has no jurisdiction over the majority of the medical provider cases that were pending in front of it because they had no jurisdiction over the accident. And again, we had to litigate that. And I'm going to talk about that topic and how we litigated and how we won on that topic. But again, this has been a contentious area. And let me talk about exactly why it's contentious. The claimant, or the applicant, I should say, files their claim, and they just have to fill out a form, and it looks like this. And if you look at this one, this is a real one from a real case, okay? This is a real claim that's on your screen right now from a real case. It says the treatment was provided to an injured worker. They have to prove that the injured worker could have brought a New Jersey workers' compensation case, and they have to show us the amount that they're disputing. Now, in this case, and again, I chose an outlandish one, because if there's one thing I like when I'm making my points is I like to be outlandish. I like to just offend you, okay? And that's, I'm trying to offend you. I'm trying to get you just angry, because I'm angry. Look at me. Okay, this isn't a suntan. This is just, I'm angry, okay? Red. Look at this case. This is a real one. I pulled this out. Just got this medical provider case. The treatment was rendered, and if you look on the date of treatment, April 18th, 2019, okay? And as you can see, they're saying there's 2 dates of treatment. When you look at them, they're identical. And the 2 dates of treatment, the doctor says, I billed you, and this is coming from a surgeon, by the way, and this was for a single level cervical fusion. The surgeon bills $180,321 for this procedure. $180,321, right? This was not the world's most complicated procedure. We do these all the time, right? This is not breaking new ground. Nobody was getting this disease named after them because this is the first time they ever did this. Okay, this is a run-of-the-mill cervical fusion single level case, $180,000 bill. And you can see here's the amount we paid. We adjusted the bill down to $21,498. Now here's where we start getting angry. They billed for a co-surgeon for this case. And the co-surgeon also billed $180,321 for the same surgery. So what we're saying here is this one doctor did the surgery, the other doctor watched, and together they billed $360,000. Now, if you're not grossed out by this, you should be. This is like offensive. This is crazy. If you ever wonder, you're down the Jersey Shore or you're out in the Hamptons and you see these huge houses and you're going like, who has these houses? Well, now you know. I mean, this is a 3-hour operation and these guys were racking in $380,000 or $360,000 they're trying to bring in. That's crazy to me. It's crazy, right? What did we pay the second surgeon? Well, we paid the second surgeon, as you can see there, $3,654. Like, thanks for watching, but we're not, that's ridiculous. Okay, so in total, they got paid about $25,000. They billed $360,000. And what did they do? They didn't say, you know what? We should be thankful that we got $25,000 for a couple hours of work. No, they said, I'm going to bring a claim in New Jersey Workers' Compensation Court, and I'm going to claim that I usually get paid $360,000 for that surgery, and that this isn't fair. Okay, so this is greedy, 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 corrupt, greedy, crooked, greedy, corrupt. All right, those are the words that should be going through your head. Now, this is also why, by the way, we encourage our clients to get a medical provider network, because you can avoid all this. If you had a contracted rate with these surgeons, you can contract in advance. You can say, hey, when you do this kind of surgery, I'm going to pay you 10 grand, okay? And you shake hands and you say, look, let's do that. And then you can avoid all these problems. But so these cases emerge maybe where there isn't that network in place. Again, my encouragement would be to get a provider network if you're going to be defending cases in this state. We see our clients generally rent provider networks, and there's many of them that you can rent from big insurance carriers. 90% penetration in terms of specializations and in-network providers, and then your contract prevents these medical provider claims. What do I mean when I say your contract prevents the medical provider claims? What I mean is when they present you this crazy bill for $360,000, you go, hey, that's cute, but remember, you're in my PPO, we have a handshake or we have a contract, and you're only going to get $25,000 for the surgery, case is closed. All right, so again, that's the strength of how getting that done. If you don't have one of those, unfortunately, the way that bill is going to be determined is by what is usual and customary in this jurisdiction. And this is where you should start getting grossed out. Again, New Jersey does not have a fee schedule for medical treatment in a workers' compensation case. Why? Well, the answer is because the employer, the respondent in a New Jersey workers' compensation case, has the ability to control and direct medical care, right? That's one of our powers in a New Jersey workers' compensation case. You don't get that in many other jurisdictions. Control and direct medical care means you can pick the doctors, you can authorize the doctors, you can deauthorize the doctor. And in advance of that doctor treating you, they have to ask you for your permission to treat your employee, which means you should be saying, hey, wait a second, are you in my network? Do you agree to these rates? You should have that contract in advance. And if you're defending cases in this jurisdiction as an employer or carrier, you should have a great provider network that you can use and rely upon. That's going to significantly reduce your costs, because what you're going to end up with is you're going to end up with basically a fee schedule in place, right? So that's why this jurisdiction doesn't have an official fee schedule, because it's leaving up to the carrier or the self-insured employer to either rent, really go to a preferred provider network, or design their own, or have individual contracts with the physicians, and then direct their employees to those physicians, right? That's the trade-off. But when you don't have that, and the injured worker gets treatment with one of these quacks, they will have the opportunity to charge you for, quote, the usual fees and charges which prevail in the same community for similar physicians, surgeons, and hospital services. Okay, so usual and customary. How do you figure that out? Well, the court has to figure that out, okay? Because again, there's no published fee schedule. How does the court do this? Well, they're going to look at what other insurance carriers or employers paid in the past, what a private health plan would pay, what a cash payer would pay, what a Medicare or Medicaid recipient would pay, what any other sources would pay. I love to direct the court to New Jersey's personal injury protection fee schedule, because New Jersey does have a fee schedule for motor vehicle accident cases. And if you really think about workers' compensation injuries, the kinds of injuries we see typically, orthopedic injuries, soft tissue injuries, neurological injuries, it's very, very similar to the kinds of injuries you're going to see in a car crash, right? So if you look at that personal injury protection fee schedule, it's going to cover like 90% of what we have in our workers' comp cases. So I like to argue to the judge, hey, can't we just apply that? And again, it's very favorable to us as the employer of care. It's very fair, right? So, and obviously these doctors and surgeons have already agreed to it because they're taking in those personal injury protection clients, okay? And so that's our argument. We say, judge, usual and customary, that's really hard to figure out. So judge, let's look at what this provider has been paid, not what they've billed other people, not what they've invoiced, because we already know they're going to invoice them crazy things, but they've actually been paid for the similar treatment in the past. Now, let's compare that to another state. And I want to give you an idea of how crazy it is in New Jersey. Same procedure, knee meniscal repair, arthroscopically repaired, right? So we're talking about a very minor surgery, a knee meniscectomy, arthroscopically performed. I mean, we're going to expect there to be what? 30 minutes operating time, no blood loss procedure, go home the same day, walking around without a cane in a week, jogging at 12 weeks, right? We're talking about minor surgery. Look at a state like New York that does have a medical fee schedule. The maximum that you would pay under the New York fee schedule for that surgery is $5,827. A New Jersey medical provider, by comparison, will bill somewhere in the order of $60,000 plus. And what we see is a roughly 10 to 1 or 12 to 1 billed ratio to fee schedule ratio, okay? And sometimes, particularly things like operating rooms or surgical center room rentals, we'll see ratios ranging up to 20 to 1. So you're gonna see these crazy numbers. They're gonna be offensive to you. When there's no contract, you're allowed to use a repricer. And we recommend using a repricer. A repricer is going to come in, they're going to apply an algorithm or apply a formula, or they're going to apply their past history or system that they have. And a lot of our clients use things like Fair Pay, or there's other systems out there. They're going to reprice the care, and they're going to issue an explanation of benefits to the provider and say, here's how much we're going to pay you. Okay. If that's accepted by the provider, you're done. But if it's not, and the provider says, well, I billed you $360, you paid me $25, not fair, I'm going to court, they can do that, okay? And that's what's driving the litigation in this jurisdiction. When we resolve these, and we can resolve them amicably between the parties, we can do a compromise, we can do a settlement. Those settlements will generally be, the adversary says, okay, we billed you $360,000 for the surgery, you paid me $25,000, I want, $200,000, and I'll say, ha, cute, I'll pay you $2,000 additional dollars, and we'll settle them for some, minor, small amount. We should not be meeting them in the middle or even paying any attention to what their demands are. They're crazy, but we should reprice them and, maybe make an offer, maybe increase what we're offering them based on an explanation of benefit repricing or using an algorithm, using a Fair Pay algorithm. Any of those things are fine, right? We'll do that all the time. So one way you can resolve these is by compromise. And you can also, of course, say, Judge, I want a trial. And Judge, I want to challenge whatever their billing method is they came up with. I want them to bring witnesses in to explain how they came up with this crazy amount. And Judge, I want to look through all of their payment records, and I want to prove that these amounts are ridiculous. Okay. Now, to prepare for trial, which, by the way, I've probably tried more of these than anybody, and you can see I put in today's handouts the medical provider decisions I'm getting. So in other words, I try them to completion, right? With the idea of, hey, let's go appeal this, let's go win if we, let's take this to the appellate division if I don't get the outcome I want, right? So you can try them. Make sure you get some discovery before you do. So the appropriate discovery in these cases. None is allowed by way of statute or regulation. The statute and the regulations do not allow for discovery, which means in every one of these cases that I defend, I file a motion to compel discovery, seeking answers to specific interrogatories so that I can defend these cases fully. What am I looking for? I'm looking for what this particular applicant was paid for the same procedure or service from as many payers as possible. I also want to establish that they accept Medicare, Medicaid, private insurance, or personal injury protection, PIP, fee schedule payments. If I can prove that, then I can argue to the judge, well, I should be paying what Medicare pays, which is going to be very, very low. Or I should be paying what the PIP schedule pays, because that's going to be very, very low. So that's going to arm me to fully defend these cases. When we're defending them, we have to focus on what the providers were actually paid, not these crazy, crooked invoices that they send. I mean, it's crazy to me that when I issue interrogatories to them, they give me more discovery. In response, they'll give me more bills that they sent to people. I'll be like, well, you got a deal here, Greg. I only charge you $360,000 for this 1 hour surgery. I charge somebody else $450,000. I'm like, well, you're robbing me. I don't care that you're holding up and burgling other people as well. Like that. I want to look at what people paid you. Did anybody actually ever pay you $360,000 for the surgery? And of course, the answer to that is absolutely no, right? So we make the argument that it's cute, you're showing us more invoices, but that's not what we're looking for. We want to see what you were actually paid, okay? What you're actually paid. And so there's a tremendous amount of litigation and fighting about what the proof should be in these cases. And the parties will go back amongst them, each other about them. So why don't these close? Why don't we just say, hey, judge, here's what the proofs show, here's what we paid, here's what our repricer strategy is, and here's what our algorithm says, and this is what it should be. Well, there's some challenges to closing these cases. The first is judges are absolutely unwilling to do their jobs and conference these cases effectively. It's just, they just don't want to deal with them. I've literally had judges say to me, literally say these words to me: Greg, I didn't go to law school and become a judge so that I could, do collections work for medical providers. I'm not interested in these cases. They don't get me excited. I'd rather spend my time working with injured workers and making sure that those trials and their settlements are fair and just. And I'm like, all right, I get that, but judge, please pay attention to these because my clients are getting defrauded. I mean, this is as crooked as it gets. Come on, pay attention to this stuff. So we've got to do a lot to focus the judges in these cases. We also have parties not ready to conference cases, meaning, the other party is seeking an adjournment, or they're saying there's more information they're looking for, which makes me furious because these cases just get adjourned and adjourned and adjourned, and they don't come to a trial. They need to be tried much more quickly. More recently, I see applicants demanding discovery from us, serving all sorts of ridiculous discovery demands on us. Okay, now I'm just going to tell you what our process here is. When we get a discovery demand from opposing counsel, we file a brief and oppose it and say, no, you have the burden of production. You have the burden of proof, not us. There's literally nothing that I need to provide you to prove how much money you get paid for this treatment. It's on you to prove how much money you should getting paid. Okay, again, I need to take a deep breath because I'm getting angry, I'm getting crazy, but maybe this is the kind of pit bull you want in the courtroom for you. But our position here is absolutely not. We're not giving you any discovery of any kind ever until we see yours, okay? You have to show us what you got. Other barriers to closure: laziness, okay? Laziness. Can't be lazy on these. We got to get angry about them. In the extraterritorial cases, which I'm going to talk about in a second, everyone's always going in the court and saying we're waiting for something. And they used to go into court, my adversaries, and go, well, judge, we think there's this big case in the appellate division that's going to change the world. It's going to change Louise cases. And so you shouldn't decide these for a while. I'm like, what are you talking about? That's like literally the job of a trial judge is to decide these things right now, not to wait for something in the future. I also think there's a tremendous knowledge gap of the bench and bar. And honestly, there's just is some sort of level of detachment as to this stuff is really wasting time and attention. It is costing employers and carriers actual money. The adjournments, the refusal to address these cases is hurting the employers of this state, and this should be fixed. All right, rant off. So let's talk about the ones that really offend me, and I see probably more than anyone else, okay? Lois Law Firm is 50 attorneys. All we do here is workers' comp defense. We don't do anything else. Workers' comp defense day in and day out. Of the 50 attorneys, 44 of our attorneys are in New York and 6 are in New Jersey. Okay, so my New Jersey practice is a lot smaller than my New York practice. But in my New Jersey practice is getting a ton of medical provider claims from our New York clients who are saying, Greg, we are defending this New York case and all of a sudden we're getting dragged into these New Jersey matters for these medical provider issues. Can you resolve them for us? Okay, so this is typical. This is happening to you. This is happening to everybody, and we defend these all the time, and we win on these. Okay, so I call these things cross-border medical claims, and I call them extraterritorial disputes. What are they doing here? Remember I showed you this slide earlier, and I said, look, the New York fee schedule for the same treatment, they can charge, they will bill 10 to 12 times more in New Jersey for the same treatment. Okay. So what are some of these crooked, quack, awful, terrible doctors doing? They have a New York claimant in a New York workers' comp case who got injured in New York, and the doctor is treating them under New York's workers' compensation law. And they are saying to that injured worker who's treating with them in Brooklyn, they'll say, hey, you're treating here with me in Brooklyn, and I'd love to do this surgery on your knee, but we shouldn't do it here in Brooklyn. You should go to the medical facility over in Bergenfield, New Jersey. Now please go Google map Bergenfield, New Jersey. Why are they sending their patient an hour away across a river into another state to go have the surgery done in the other state? They're doing it on purpose so that they can then file an application for provider payment in New Jersey and claim that they should be reimbursed at usual and customary for that same medical treatment. It's the most obvious, corrupt, fraud, wrong thing that you could, I mean, there's no medical reason why a New York resident would be shipped across state lines to go have their treatment done in New Jersey. And you will see it. There are a whole host of these same-day surgical centers, right? Metropolitan Crossing is one that just comes to my mind, right? The Surgicares, the Surgicord. Why are they sending people to New Jersey to get their treatment? It's because they're engaged in this sort of medical fee arbitrage, and because they have a number of predacious attorneys who are going to robo-file these claims for them, okay? Court doesn't address it. They're not doing anything about it. We're doing everything we can to bring this to the attention of the courts and fight these kinds of cases, okay? So as soon as they changed the law in 2012, all of a sudden you see all these New York patients getting all this care in New Jersey. Lots and lots of filings for these in New Jersey all of a sudden. This year, about 1 in every 5 workers' compensation claims filed in New Jersey, 1 in 5, is actually going to be a medical provider demanding more money. And they go into court with these extraterritorial disputes, with these old treatment dates. Because remember, the statute of limitations is 6 years. So these old treatment dates, 2018, 2019. Now we're going to litigate how much someone should have gotten paid. Come on. We have applicants' attorneys going to court and say, Judge, my doctor did $360,000 worth of treatment. They only got paid $25,000. You got to do something about this. Trying to make these fairness arguments. They try to pick which judges they get. They try to pick which judges. And how do they do that? How do you do that? Well, when the applicant's out of state, in New York in particular, they're going to put that into Hackensack, New Jersey. So you can almost know which judge is going to end up in front of. I mean, it's ridiculous. Okay, this is going on. Then you've got on the other side, you've got these lazy defense counsel, right? New Jersey is full of lazy, sloppy workers' comp defense attorneys. Sloppy. Adjournment hounds. Everything gets adjourned. They never try anything. They just adjourn things. Just adjourn it. No, just adjourn it. We'll get it a couple of years from now, okay? And the courts have been allowing that. The other thing is the applicant attorneys, there's only a couple law firms that are doing this, and they're robo-filing these claims. And they couldn't possibly make all the appearances on all the hearings that generate from all these thousands and thousands of cases that they're filing every year. So these attorneys are spread so thin, they're asking for all these adjournments. So this has become one of the most frustrating aspects of New Jersey workers' compensation law. If I was the governor of the state of New Jersey, this is one of the first things I would address. I'd go right after this. Anyway, I'm not the governor. So moving right along. What do you do when this happens to you? How do we defeat this? Well, let's talk about my case. This is the model case. This is the only one that you're going to find that someone actually took it all the way to trial and got a decision. And this case probably sounds like a lot of yours. Guy is injured in New York, employed in New York, okay? Files a New York workers' compensation claim, has a New York recovery in his workers' compensation claim, but he lives in New Jersey. And so because he lives in New Jersey, he went and got authorized or permitted treatment, medical treatment in New Jersey. I argued that's cute, but the applicant, the medical provider, cannot file a workers' compensation claim in New Jersey. They cannot do it because they do not have jurisdiction over the underlying claim. So the only contact this guy has in New Jersey is that he lives here and he got medical care here. Okay, that's it. And that argument is very similar. And I'll tell you that we're defending hundreds of these. I have hundreds of them with facts that are pretty congruent to this circumstance. You probably do too. Again, maybe they live in New Jersey, maybe they don't. They got medical care in New Jersey by happenstance. Maybe their doctor sent them across state lines, very common. Maybe they lived in New Jersey, so they've got medical care down the street, maybe. And now you're defending one of these cross-border workers' comp claims. Well, take heart. In this case, we argued that the New Jersey court had no jurisdiction to decide how much this applicant, this medical provider, should be paid. We won. The judge agreed with us, wrote a great opinion, which I've included in today's handout materials. What's interesting, you should note this, is the applicant loses this And they lose it on a legal ground. You know, the judge says, look, I looked at all the facts here and I applied the law and I find no jurisdiction. I think residence alone is insufficient. Treatment alone, insufficient. You can't have this. We can't have these cases here. That impacts hundreds of cases, maybe thousands. The applicant doesn't appeal. Why? They don't want case law. They don't want the appellate division to come in and give a case law that we can then waive or dismiss all the other ones. So we're left with case-by-case dismissal. And that's what we're doing. We use this decision to support motions to dismiss, and we have gotten dozens, maybe hundreds of dismissals since this decision came out. And again, this decision was finally rendered in February of 2023, as you can see by the date the judge signed it. This has saved our clients millions of dollars. In addition to the Watrick decision, I just want to bring up that you have some other additional authority. First, New York's fee schedule itself says where you have a workers' compensation case, General Ground Rule 16, New York should still have jurisdiction over that case. And, you know, New York can price it. They can use a conversion factor. And in fact, New York publishes relative value units, so the fee schedule will apply. And I say this out loud because we need to be ready to argue when the opposing counsel goes, well, judge, it's unfair. If you say you have no jurisdiction, my client is out of luck and they've got screwed out of $360,000 in treatment that they provided. We said, no. They have a valid claim. They can go into New York and make a claim over there. Now, New York's going to look at this and go, what are you talking about? Fee schedule applies. Goodbye. Okay. So this is a tremendous way to save clients money. The takeaways from today's presentation is these crazy, crooked medical provider claims are now taking up about 20% of the cases in our division. If you have a contract, they're relatively easy to defend. We are prepared to defend those for you. We'll usually provide the testimony of the repricer, some evidence information, evidence-based repricing, and we will generally get a good resolution to those. Jurisdictional cases, where the claimant has crossed over into New Jersey to get medical care, or the only contact with New Jersey is they got medical care in New Jersey because they live here, you should win those cases. You should get dismissals in them. You should get great outcomes in those. And we have to overcome the barriers to this, which is getting the judges to actually intervene and pay attention to these cases. That's my job. All right. I see we're starting to get questions piling in, so let me answer some of their questions. Okay, I'm going through here. Somehow there seems to be the same person has asked the same question many times. Like, it looks like we have some kind of spamming going on here. Okay, scrolling through. The person asked that and left, so I don't really understand what's going on there. Okay. First question that doesn't look like it's spam is from Erica. She says, Greg, Greg, if the provider has no recourse in New York because they're not New York providers or because it's past the New York statute of limitations, is there anything that would make the claimant in New York responsible to the provider for the difference in the billed versus paid amounts? Okay, so this is a great question. No, absolutely not. Just like the New Jersey workers' compensation law protects the petitioner, it says you can, because of a medical billing dispute between the carrier and the provider, that could never, ever be transmitted or made the responsibility for authorized care. Okay, I'm talking about authorized care, can never be made the responsibility of the petitioner, and nor can it even tarnish their credit record or be placed against them as a mark against their good credit. New York has the same rule, which says that the provider who's providing treatment in accordance with New York's workers' compensation law absolutely may not seek redress or go after a claimant in a New York workers' compensation case directly. So there is no danger where the New Jersey workers' compensation court says, nope, there's no jurisdiction here. There's no danger that the claimant would ever become personally liable under either state's law for the difference. And that's really to protect workers and protect maybe someone who's innocently caught in the web of these corrupt physicians. So you don't have a concern or an ethics concern or even a moral concern that could possibly happen. So very good question. And that's the only question I got. That wasn't a spam question. So thank you for asking it. I hope today's conversation was useful for everybody. If you enjoyed this kind of stuff and you like this kind of nerdy workers' comp talk and you like seeing me rant, consider signing up for our newsletter. You can sign up for that on our website, loisllc.com. And if you really like this kind of stuff, you should check out my partner's podcast. It's called Third Fridays. Christian Cison leads it on, guess what, the third Friday of each month. And it's about a different topic in workers' compensation law every month. So really high level, very exciting conversations. A lot of the time, a lot of cutting edge stuff that he's talking about. So please check that out. All right, everybody, I hope you have had a great summer so far. I know summer feels like it's coming to an end. We're starting to see more and more commercials. My kids are like crying every time they see them that say back to school sales, right? I hope you have a great rest of August and a great summer, and I look forward to seeing everybody in September for our next New Jersey workers' compensation webinar.